morning. We continue the cross-examination of Mr. Roskoznik.
Mr. Chairman, before we get started, I just wanted to alert the tribunal that we have a new member on our side of the room, Mr. John Anderson, our expert in British Columbia law. Thank you.
Thank you. So, Mr. Bekes.
Yeah. Thank you very much. Good morning, members of the tribunal. Good morning, Mr. Rozložník. As all of you are aware, we have added some documents both in the binder that we distributed yesterday, and there's even a small, there's no translation.
I believe that the channel needs to be set for Mr. Rozložník. He has the wrong channel.
So, Mr. Rozložník, I was explaining that this morning we have added a few documents into the binder that you had from before you yesterday, and there's also another third binder, a small one. And I believe that just for convenience, we will start with the documents which are in the third bundle so that everybody can get rid of it and then work just the second bundle that we had yesterday. And the document that we have added into the third binder is tab 47, C230. Which is 47. It is in the, it's bundle 3. Yeah. So it's C230, and this is the 2004 plan that we foreshadowed to some extent in our discussion yesterday. So please, Mr. Rozložník, go to the first page, and on the first page you have the date when the plan was prepared. The date is November 1, 2003, is that correct?
It's correct.
Thank you. Now I would ask you to go to part 1.2.3 of this document. It's called Method of Opening and Preparation, their segmentation, time and material distribution of work.
Oh, no.
Yeah, correct. No.
Yes.
And we remembered that the structure in the plan from 1998 was quite similar. And so here you're explaining what you propose to build in order to open the deposit. And in the English translation, it is at the beginning of the next page. You state, on the basis of the height difference between the valley and the deposit, the opening from the Dlhá dolina can be accomplished either by a winze or a pit. After assessing all general advantages for development, a winze was chosen as the main mining works. A vertical shaft for ventilation An emergency exit and transportation of packing material was shown to be the best option for the mine outlet. Sir, this actually is a copy-paste, sort of, from the plan from 1998, because it does not mention the adit that we discussed yesterday. Is that correct?
It is correct, but yesterday we've discussed the POPE, P-O-P-E, is elaborated for winds. The second part using the added was only an idea as a consequent consideration. This project only concerns the winds, no added. With the approval of the mining office, this is only about information about an added. I was explaining that yesterday.
So under this plan and the authorization of mining activities, which was issued on the basis of this plan, the only opening of the deposit, which was approved by the district mining office, was the winds. Is that correct?
That is correct.
Then I would also ask you for clarification of one point. I seem to understand yesterday that you were saying that you were planning to build a decline or winds with a smaller profile than in 1998. Is that correct?
Correct.
The one thing which puzzles me is that if you look at the specification of the winds or decline in this plan, it states that the profile is 20.25 meters square. And when I looked back at the plan from 98, which is tab 23 if you want to check it, I realized that the profile is actually smaller in the 98 plan than here. Not by much, but I will give you the exact number. I believe it's 18 meters square there. Do you have any comments, sir?
Let me have a look at it first. How many square meters it was in the previous one. However, we've always was saying that there was a rough and a light profile. There are two different profiles. So when if there is a difference, if it is true, there are 20.25 and 18 square meters, I see no problem in that difference, because the profile of that corridor or tunnel is 4 by 4.5, which was according to the plan before.
In this winds or decline is not smaller than in the decline that you intended to build under the 98 plan.
Áno. Asi tak.
I would explain it as follows. As I was explaining yesterday, we were planning a half profile, so 12 square meters instead. That can be consequently agreed upon with the mining office, that we are going to go ahead with a different profile. And the mining office would just approve it consequently. So it was a sequence of events within certain deadlines by which we wanted to lengthen the profile. That is why we've initially used the data from the first POPE.
Now, please, if you look still at the specification of the new decline or winds, and it will be useful actually to keep open the specification in the 98 plan. Another difference is that here the downgrade is steeper because it's 12%, while in 98 it was 10%.
Nie bolo 10, bolo 12.
It was not 10, it was 12.
No, je to.
It's tab 23.
To je to.
I have it in English.
Máte pravdu, bolo tu 10.
You are right, it was 10. However, the design was done by Mr. Heidecker. But later, about the contract for works with Rima Muraň was already 12% decline contracted.
And I also have the impression that the winds you were proposing to build in 2004 was somewhat shorter than the winds from 98.
Súviselo s tou
Yes, it was related with the profile. I explained it yesterday, because by increasing the decline to 15%, the winds would end up being substantially shorter. All the data would then be submitted consequently for approval to the mining office. Steeper decline, a smaller profile, and shorter distance of the winds.
Now let's turn just a page in the English version, and let's go to point 1.2.3.2. And there you describe it's just in the new plan, in the 2004 plan. And there you describe additional verification work during winds cutting. Why was it needed, sir?
Je to veľmi dôležité.
It's very important because when we were approaching the deposit by cutting, major tectonic disturbances were discovered. So through our cutting works, or drilling works, we wanted to find a precise locations of these tectonic locations and disturbances, what materials are they composed of, because that impacts the drilling work itself. Being aware of which environment we are going to go into, so we can have a proper reinforcement for that. That is a commonplace mining activities.
Forward to section 1233. And this is where you describe what will or may follow after the opening of the winds, or rather out of the completion of the winds, I should say, and the additional verification work, that's how you call it.
Práve to je ten postup.
That is exactly the informative proposal for mining office, how we shall proceed further once we have completed our winds and we shall approach the deposit. So we would notify them in advance that we shall be arranging for zoning permit for locating the adit. You can see in the consequent map in the appendix.
If we look at the text of this section 1233, I will read from it. So my understanding is that actually you are proposing two options. One option, which is called in the English translation Alternative 1, is winds. The translation, I suppose it's supposed to be the adit. And Alternative 2 is still the old one, winds or decline, and I would call it the chimney, because that's the one thing I can visualize the
Na to nás
easiest.
upozornil aj Banský úrad.
We were reminded of that by mining office that there is a stylistical mistake as an Alternative 1, Alternative 2. Mining office had approved work only for Alternative 1.
Mr. Loznik, I think that a while ago we were discussing what was approved in the authorization which was issued on the basis of this plan, and you mentioned that it was only the winds or decline.
No však to je tá alternatíva.
That is the alternative number 1. It is winds. Adit is not supposed to be here. We've already clarified it with the mining office.
The adit was not supposed to be there.
Nie.
Yeah, and this is probably also because, as you stated at the very beginning of this part, You presented this as the next steps or step in the opening work, so far without actual executive design documentation in alternative form. So this was not binding in any way.
Right.
You did not submit the
yeah.
documentation necessary to have it approved, right?
Yes, correct. We never submitted it to neither the pit nor the adit, the chimney.
Further down, it says that according to you, alternative 1 with the adit represents the only optimal solution for the problem-free economic mining of the deposit. And then there's another sentence which I find interesting. The decision on implementation of one of the alternatives will be taken by the investor, that's Rosmin, I take, after evaluation of the results of work from the implemented wins. Could you please explain this sentence?
Of course. As long as we would be proposing later submitting design documentation for added, we would have to consult it with the owners because that would result in increasing investment. It's a 4.2 long excavation, which calls for increased funding. We've discussed this with the investors, and they've agreed with it. And we've agreed that during drilling the winds, we will already begin submitting application for approval of the added. So they've agreed that we can, meanwhile, prepare the documentation for approval.
Okay. Sir, would you agree with me that you would not have been able to commercially operate the mine until you prepared the second opening? Or the second entrance to the mine, either the chimney or the adit?
I'm not sure I understand exactly what you mean.
I'm advised that there was incorrect translation, so I will repeat my question. Would you agree, sir, that you would have been able to commercially operate the mine only after the second entrance, second opening, or second point of access to the mine is prepared?
No,
It is not precisely so, because by gaining access through the winds to the deposit, being able to take the necessary multi-ton large samples, that would give us a certain image of the deposit much better than laboratory tests. And I'm convinced that the tests would end up being positive. So that was already background for the alternative one of opening the deposit be more precise. It is not a problem that as long as you have arranged for zoning permit for the added and have everything approved, and then take the sampling from the first alternative, from the laboratory multi-ton tests would end up being negative, then you're going to have to decide whether you're going to continue on the deposit, whether the deposit has such positive value. It's quite commonplace.
For the explanation. But what I had in mind was commercial operation of the mine, and I believe that under Slovak legislation, and we discussed that yesterday as well, a mine can be operated only if it has 2 points of entrance for safety reasons. Is that correct?
It is correct that you need 2 entries. And we had chimney, or we had designed in our design. And so if we were to gain access to the deposit through the winds, we would already be excavating exclusive mineral. and then by which time we would begin already implementing the chimney, which would end up being much shorter than the one 320 meters tall I mentioned to you. The one we were proposing only had 200 meters height. So technologically it was thoroughly verified by Mr. Heidecker, who had much experience about these issues.
But for the construction of the chimney, you would have needed to submit a new plan and obtain a new authorization of mining
Doppelnov.
activities. Is that correct?
Doppelnov POPD.
You may always submit an addendum or appendix to the POPE.
But the chimney was not approved under the authorization of mining activities issued in May 2004, was it?
It was not approved. However, as I say, you may always submit a request for additional approval, submitting additional documentation. When you locate the chimney somewhere in the forest, you again have to approach the forest administration to gain permit from them. You need to build access road to the chimney. However, it was not yet necessary to be involved in that work. That was sufficient to be left for later, making sure that you have all the ownership relations already resolved, because design and in theory we've had everything prepared already. Hydrogeology, conditions, everything that was already prepared beforehand. So all you need to do to deconflict the conflict of interests.
To part 1.4 of the document.
No.
Well, I will ask the follow-up question. I will ask the question. Mr. Olozhnik, before going to that, could you please explain what you mean by conflict of interest?
Conflict of interest, not really a conflict as such, but it's an encounter of interests rather than conflict. It means various organizations which are somehow related to land or whatever else they need to approve for you to be able to conduct any work, let's say in a forest. So then they need to approve it. Let's say it's an environmental agency. It's hydrogeology issues. There are forest land. It's forest owners. So it's a complex of varied encounters of interests from varied areas, which you need to beforehand, before you get authorization and the approval of the mining office, which you need to also obtain permit from.
And owners of land plots, do the owners of land plots have a legal obligation to agree to what you are planning to do on their land plots?
Isté, že musia súhlasiť.
Yes, they have to, indeed. They have to.
Musia dať
They have to give a positive answer.
An obligation to do so.
Je to
Now, is it an obligation? If you do not have an approval from them, mining office will not approve it for you.
There may be a translation issue. If, let's say, I'm the owner of a land plot that you need for your construction, you come and ask me for my approval, and for whatever reason I say no.
potom mám problém
Then I have a problem,
riešiť.
and I have to address it.
Okay, so now let's go to this part 1.4 that
It's really 1.4 or 1.2.4?
thank you, Mr. Chairman. Yes, it's 1.2.4. Yes, I was too quick.
Ja jedna bodka, dva, štyri.
It the English translation again uses the word excavation, which is forbidden, but it comes from the claimants. I will use it in Slovak then. It says dobývacie methods, information on their approval, justification of use, special measures for introduction of new excavation methods. And here you inform the mining authority that you will be used a method called mechanized underhand stoping by heading method. And then a little bit further down, you specify the basic spatial demarcation of the excavation block. Do I understand correctly that the, or I should have said dobyvací block, apologies, that the dobyvací block is located deep underground surface?
Vysvetlím vám, čo je.
I'll explain it to you what it means, the heading method. In order for you to be able to start excavating, you need to demarcate an area which is optimum, which contains more than 60% of talc. And that's where you do mining work. As proposed here, it's already also graphically depicted here, where you begin drilling and you demarcate the disturbance, geological disturbance, by doing your mining work in the middle and underneath. That's where the part is which whoever's going to be excavating the deposit, that is the part that you're going to have to excavate out. And then yield is calculated according to individual blocks. So they know the volume and the tonnage, how much from which block they need to excavate out.
Deep under the surface
Podzemí, už.
It was on the ground.
to get to it, correct?
Samozrejme.
Yes, of course. The initial design, I was explaining yesterday, when the winds was classified as the main mining works, and we got to the top of the deposit, afterwards there needed to be a spiral bore drilled. After each 20 meters, you would bore a horizontal added. So that has had its impact on the excavation method, as described initially. It's commonplace in the world, and Mining Office is familiar with these methods, and they have no objections against that. It's a commonplace method when mining, and you may even ask me later, except in cases or why we are proposing the baseline of all the adits, which we are going to be reinforcing with concrete mix.
Shorten the discussion of this point. Did you ever start to dobyvat in accordance with this plan?
Podľa toho,
Well, according to this plan, I do not know what precisely you mean under the term dobývanie, because we were conducting mining activity.
Because at the beginning of your answer, I will read the answer to you. Am I being caught for not following the English translation? Sir, I will reformulate the question again. I believe that, at least in the response that you gave in the Slovak language, you said that, in order to start dobyvať, you needed to get to this dobyvací block. Is that correct?
no isté, že.
Well, yes, quite certainly. we need to first of all localize the specific area which needs to be mined, which needs to be excavated.
To construct the winds to get to the block which is located deep under the surface. Is this correct?
Ešte není
Well, it's not that deep underground, it is at the end of the winds. We will reach the winds, we will reach the block by the winds. We don't need to go any further. We simply approach the deposit. We take a technological sample, high tonnage sample, according to the approved mining method.
Height difference between the entrance to the winds and the upper part of the deposit where you planned to get to.
Teraz to vám presne neviem.
Well, I cannot give you the precise answer, but I think it can be found, and definitely is in the document. The altitude, the difference in altitude, at my estimate, is about 200 meters.
Ever get physically to those 200 meters down?
No, tou úpadnicou, ktorú sme začali,
Well, the winds, which we have started, obviously no. It only had 90 meters in length.
Okay, now I will ask you to the following tab, still in binder number 3. It's tab 48. It does not have a C number because it is a reprint of a table that we submitted on page 10 of our rejoinder, which Mr. Rozhnik is filing in this arbitration, and I appreciate that you have never seen the document, and I will not ask you any questions about this document. I will just use it. I represent to you, sir, that this is a list of various I would say problems with the applications for permits and otherwise that Rosmin was making throughout its history. And for example, in the third column of this table, we state the deficiencies of the requests which were made. And very often we have, actually always, we have a problem with incomplete documentation. Sometimes we also have a problem with non-payment of administrative fee. For the interest of time, obviously, we will not be discussing all of those, but I would now point you to documents pertaining to the last line in this table, which is actually the request for the authorization for mining activity, which you filed on the basis of the plan that we have just seen. This, in principle, we should be done with binder number 3 now, so you may put it away to make it easier for you on your tables. And please go to tab 44 of binder number
So what
2.
was the purpose of that table of your memorial that you showed? You listed him.
I just showed it.
You just showed it. That's you think a cross-examination question.
Yes.
Show him your memorial, a page of your memorial to a technician.
Okay. Okay. So, and this actually is the authorization of specific mining activities that you got in May 2004, right?
je to v poriadku.
Yes. The date
It's correct.
44, yes. C27. It is dated May 31, 2004. Yes. And now let's have a look at page 3, which is, it starts with reasoning in the English version.
No, tu.
And At the very beginning, it describes the procedural history of this request. So the first paragraph states that there may be a translation issue. I am informed. I meant procedural history, procesnú históriu of this proceeding. I will ask you a question. So first, the first paragraph says that the request was filed on 8 November 2004. Is that correct? Can you see that in the first paragraph?
Áno, tak keď je to tu, určite je to tak.
If that is the case, it definitely must be also the situation in reality.
That's what I think I said. Oh, apologies. I meant November would be too late. January, yes. And then the second paragraph explains that the mining authority examined the requirements of the submission, completeness of the plan and documentation, solving of public interests that we mentioned, then protected according to special regulations and compliance with the principles of the mining technology during the securing of the rational use of the exclusive talc deposit, whereby it discovered that the submission and prescribed documentation does not fulfill these requirements. And it goes on, and it states under number A that together with the submission was not paid the administrative fee according to whatever item. And that was 1,000 Slovak crowns. Divided by 30, I think it's like 30 euros. Is that 33 euros? Is that correct?
Je to správne.
Yes, that is correct. It was paid afterwards. I don't want to elaborate. We sent the official stamp by post, and they claimed it never arrived, so we've paid in a different way. I'm not going to go into any detail on that.
You mentioned, how was it translated? Yeah, the official stamp. So the way you were supposed to do it, would you agree with me, sir, is that you were supposed to go to a post office, buy this stamp, official stamp, glue it on the submission and send it to the mining authority. Is that the most usual way how those small fees are handled?
Uhradili sme.
Well, eventually we've paid. I'm not going to go into any detail on that. The way how we did it, it doesn't make any difference. We've paid the 33 euros.
Paid only later, correct?
O pár.
Yes, perhaps several days or so.
And then in point B, there are some missing documents. And then in point C, there is identification of problems with the plan. Problem number one is that the requirement of securing two entrances, the one we discussed a while ago, is specifically mentioned. And then under 2, there are some other, I would say, more technical problems mentioned there. Is that correct? Did your plan have those deficiencies?
Neboli to
Well, I wouldn't say deficiencies. We didn't know about these annexes. Nevertheless, we made them, we've submitted them, and we sent it to the mining office. Everything was delivered to them as required.
And if we go down, how many is it, to the second paragraph after the list, it mentions that the applicant, by its submission, which was protocoled on the mining office on 11 March 2004,
Kde je toto?
amended its preceding submission for the requested requisites. So this is what you alluded to in your previous response when you said that you provided all the information which was required by the mining office. Is that correct?
správne.
Yes, that is correct. We've eventually provided documents.
And you can see here that the requirements which the mining office had were quite clear. So you had no doubt with respect to what you needed to supplement or not.
Boli úplne
Yes, that was very clear. The second gentleman, Mr. Balcho, a project designer who was responsible for this, he prepared all the annexes and delivered them. Well, not him, but Rosmin delivered them.
12 months later, you obtained this authorization of mining activities.
Isté, že
Correct, yeah.
definitívne rozhodnutie
Well, yes, we received the final decision for the execution of the mining works, and also we received the permit.
Agree, sir, that this authorization, yeah, there's a problem in the, apologies, there's a problem in the transcript. It's not supposed to be ex-computation, but authorization in my previous question. So, sir, would you agree with me that this authorization was actually conditional?
nesúhlasím.
I wouldn't agree with that. This was the final approval in order for us to carry out mining activities.
Please go to page 2. It states, for the execution of the authorized mining activity are determined these special technical conditions.
Aha.
Yes. So, is it your understanding that you had to comply with those conditions?
Isté, že sú.
Well, yes, quite certainly. This was my understanding, and we've added them. Respective experts who were authorized and who were tested in front of the mining office eventually did it.
Until these conditions were fulfilled, the authorization was conditional because obviously nobody could know whether you would or would not be able to fulfill those requirements.
President, aren't we moving to legal issues now? I think that the gentleman answered everything he could.
Mr. Garavi, I have to repeat what I said yesterday. This gentleman was the responsible person for mining activities at Rosmin, and it was his personal duty under applicable Slovak legislation to understand and apply Slovak mining legislation. I am not asking any questions of civil law, in any other field of law, just mining law.
He advised legal questions, your question. You know that. That's why you're asking them. Ask a factual question.
No, I
So
think
whether he met the
this is
technical-
within the sphere of competence of the witness, I think.
Well, his competence is to answer whether the technical conditions have been met, have started, but not whether it's legally conditional.
He must have some knowledge of the legal obligations when he submits a request for an authorization.
Yes. Okay. Could you please answer? You don't have the screen, so I will repeat my question to you. Okay, so do you agree that until these conditions were fulfilled, the authorization was conditional because nobody could know whether Rosmin would or would not be able to fulfill those requirements?
Na to vám
Well, I can answer only by my statement. For me, the key is a decision by the mining authority issuing a permit to carry out mining activities. So we did comply with all the requirements stipulated by the district mining authority. This decision was issued. On the basis of this decision, we've started our works. Everything else, I cannot comment on that.
Okay, I will.
I'm not sure about the translation. For the execution of the authorized mining activity, I don't know what is the Slovak word and in what sense the word execution is used, because it's an ambiguous word in English. And because these could be conditions precedent, or this could be the consequences of the granting of the authorization. So I'm uncertain about that.
Môžem ja odpovedať?
Absolutely.
Predsa je tu jasne napísané.
Well, it clearly says that the decision was made that we permit mining activity. These are the very words.
Okay, I will go to something which may be easier. Right after the list, you have the paragraph which says, by this decision are not affected rights and duties according to special regulations comprised in decisions and statements of other authorities of the state administration. Can you see that? Please, this is right after the numbered list.
Toto? No. No však my sme tú dokumentáciu.
The documentation which was prescribed by the Mining Act.
There's a list running from 1 to 6. And then there's a new paragraph.
Yeah.
Which states, by this decision are not affected rights and duties according to special regulations comprised in decisions and statements of other authorities of the state administration. Can you see that?
Čítam.
I'm reading what you are referring to. It's written the way it's written.
Meaning of this provision, sir.
I'm unable to respond to that, simply.
Sir, I represent to you that it means that if there is another decision issued by another Slovak authority which prohibits mining activities, or which imposes conditions on those mining activities, then this authorization issued by the district mining office does not prevail over such other decision. Did that refresh your memory, sir?
Žiadne rozhodnutie.
No decision of any other state authorities were received by us.
Agree that the interpretation that I offered to you is correct?
Nie som
I'm not a lawyer. I'm not able to respond to that.
Okay. Let's go to page... In the English version, that will be 4, 5, 6, 7. I am not sure what it is in the Slovak version, but in English it's at the very bottom of the page. And the paragraph states, different conditions or measures arising from the relevant legal regulations concerning water and execution of activity in areas of hygienic protection of the water supplies are in the competence of the water authority. Can you see that, sir?
Ano.
Yes, I can see it. All particulars and approvals from water authorities were obtained by us.
Which restricted your ability to start mining activities in
Už si
those
nepamätám, ale
permits.
I no longer remember, but if they were, we would have resolved them.
We will come to that later, but I will show you a decision which was applicable at the time, which actually prevented you from starting mining works until you finish and commission the water treatment facilities. There was
That document, instead of talking, why don't you show them the,
I can show the document now if you wish. Oh, absolutely not. And thank you for advising me how I should conduct my cross-examination.
the gentleman, you're representing a legal decision without showing him it. He's not a lawyer, he doesn't have the decision. That's all I'm
full
asking.
opportunity to comment on it. I will now continue with my line.
But, I mean, the remark is correct. I mean, you're not making an argument in front of the tribunal, you're cross-examining the witness,
Okay.
so if you cannot...
I will
answer.
just foreshadow it. If we might go to document, it's tab 12 in binder number 1. That is number 57, R57. Yes. Now, if you start from the end of the document, you have the recorded by Mr. Buffy, and then I think it's third paragraph from the bottom. Starting with Rosmin has performed,
Áno.
yes, and performs works related to the completion of surface water management construction due to the limitation of performance of mining activity by decision of Rožňava District Authority Environment Department number, and there's a number of the decision, of 9 August 2002, which is conditional on putting temporary surface buildings into use.
Áno, viem to, dali sme...
Yes, I'm aware of this. We have put the structures to use, and the condition was that the authorized person must be designated who will observe this. It was all arranged, was engineer Bachňák, so all the conditions were met by us.
The minutes say, do they?
Museli by ste mi...
You would have to show me.
The paragraph. The paragraph says Rosmin has performed and performs, still performs, works related to the completion of surface water management construction.
Aha.
So these
Možno-
minutes suggest that the work has not been finished yet. Do you agree with me?
Pozrite, ja...
Look, I've already explained this to you, that Rima Moráň had not put to use a single surface structure. It was Rosmin who was making all the arrangements, getting all the final approvals, including a bridge, which I explained about yesterday, was all done by Rosmin. And also putting to use of water treatment facility for the mined out water. All was arranged by us. It was all in accordance with what you are saying.
The only construction object that you needed to put into use in accordance with this decision of 2002?
Isté, že
Certainly. I'm not sure whether it still pertained even to some electrical lines. We were making all the arrangements because we were purchasing high voltage line from Rimamuran, which was made accessible. But later, problems had occurred. We gave them a 1 million crown deposit because we wanted to purchase it for 4 millions. They made it accessible, but then they have withdrawn from the contract.
a iné objekty,
And other structures, everything worked as it was supposed to.
Your memory, sir. Let's now find this decision. I will ask you to go to document tab 37. It's exhibit C259. And because the document is very voluminous, there are some stickers there for easier orientation. This document is the contract for work that you signed with Siderit, the company which was supposed to build the winds.
ale toto není zľava tu.
Yeah.
Aha, tu.
Yeah. Well, we will get there.
To je v
but,
angličtine,
yeah.
ne? Možno toto je to, ne? To je pomlkový list.
Well, okay, let's go there. I will present to you. This is the agreement you signed with them. And this agreement also attaches in annex number 4. This is the first sticker. The annex is called Mining, Building and Water Law related decisions. And then if you go to the second sticker, in the English version, it states mining permits, but this is actually bad translation, so I would ask the interpreters to go to the equivalent in the Slovak language and confirm that the correct translation would have been water-related permits. Again, it's one of the stickers further down in the text, but you probably don't. Do they? Yeah, you have it in the... Well, I'm asking about the interpreters who also have these. Okay. Okay, so under this tab we have various decisions. And before going to the decision in question, we may go to the last one, actually, the last sticker. Oops, you only have the 2 stickers? Apologies. That's this, I will try to count the pages. It will be 1, 2. Well, actually, it's the last page before the Slovak version, so that's maybe the easiest way to find it. Yes. It is the decision of the District Office of Environment in Rožňava, which was issued on October 26, 2004. Correct? Is everybody on the right document? Well, in the Slovak version, it will be the last document of the whole, the last page in the whole document, yes. And there, basically, I will read it to you because the water authority here recaps the status of various permits. The district office, this is the paragraph after some space left blank. The district office in Rožňava is the competent state water administration authority pursuant to certain acts. After assessing the reasons submitted by the work investor for which the work could not be completed within the deadline set, determines the completion date of the temporary surface structures, waterworks implemented as part of the work drifting of the winds, talc deposit of Gemerská Poloma, to May 30, 2005. Then the second paragraph states, in implementation of the work, conditions must be observed as laid down in the decisions issued by the former district office in Rožňava, Department of Environment, one dated September 23, 1999, and then also the decision that we are discussing, and which I will show to you in a while, from August 9, 2002, which determined conditions for draining mining waters and monitoring surface waters, dated July 28, 2004, issued by the District Environment Office in Rožňava. And then it states, the work can be used only upon the final approval decision. Builder, within 15 days of completion of the work, shall submit a proposal for final approval of the work to the State Water Administration Authority under the Building Act in effect and the Water Act. And then at the very end, conditions of the permit to the temporary use of the structure CS24, Mine Waters Treatment Plant, dated July 28, 2004, which defined conditions for the use of the mine water treatment plant, shall be met by October 30, 2004. Can you see all of that, sir?
No, piste se.
Yes, certainly. It's exactly as you said.
Is my understanding correct that the surface structures which were to be built and which were the subject matter of this decision actually are in two categories? Category 1 is the one water structure which is mentioned in the last paragraph, and then all remaining ones are subject to the first 3 paragraphs. Is that correct?
Look, all I can say to that is that which was not completed with regard to the water-related works, we have completed it. It was done by second contractor, Siderit, who had completed the water treatment plant, which was not completed by Rima Muraň, with drainage into the creek. Over the entire period, we had guards there who would measure drainage amounts of water, temperature of water. An appropriate hydrogeologist also was available, with whom we had a contract, who would be sampling at regular basis the wastewater, had them analyzed, and supply reports about the analysis which we provided to the water authority. Everything was in order.
Actual question. If we look at paragraph 3 here, it says the work, or the third paragraph of those that I read to you.
Otsek 3.
No, it's the third one,
yeah,
the third
exactly.
paragraph of those that I read, so it's the penultimate paragraph of this decision. It says the work can be used only upon the final approval decision. Builder, within 15 days of completion of the work, shall submit a proposal for final approval of the work to the State Water Administration Authority under the Building Act in effect and the Water Act. So question number 1. Did you submit a proposal for final approval of the work to the State Water Administration Authority?
Týka sa to
This pertains to the item, the SO024 water treatment facility plant.
Túto stavba, ale ktorú stavbu?
Now, which construction? I'm not sure which construction or structure we are talking about. What are we talking about?
Relates to? Okay.
Lenže môžem k tomu niečo vám
Yes.
povedať.
Can I say something about this? I'm not sure why we are evolving this particular topic.
This refers to, do you remember, sir, that you submitted requests for approval or for construction permits for several water treatment related construction objects?
Nepamätám si presne.
I don't remember exactly, but I know that we, as long as we would receive a request to submit something, we have always done so. I cannot prove it to you now 100%. I don't remember anymore. It's been years ago.
The decision from August 9, 2002. This is a bit. Please go back in your binders, and that will be the 5th sheet. So 10 pages back. In the same within the same document. Yes. And this is a permit, as you can see on the first page, to change the water structures erected as part of the temporary work of drifting of exploratory winds, talc deposit of Gemerská Poloma before completion, according to the project documentation prepared by Mr. Bellow, etc. And change to the work applies to the following structures. And there you have a list of 8 structures. Can you see that?
Áno, je to tu.
Yes.
Yes, it is here.
Of those 8 structures is the mining wastewater treatment plant.
Áno.
Yes.
We go back to the permit that we were discussing. The remaining 7 construction structures from
Help
the...
us where we are, please, because we are completely lost.
Where you...
Ja som stratený.
I too am lost.
2002, decision August 9. Okay. This...
I would appreciate if you can continue your efforts to be patient with this witness, because if the tribunal doesn't follow, you can imagine the stress, the age, and of this.
I apologize, I didn't realize that the tribunal was not on the right page. Yes, 10 pages, yes, there's the 10 pages, 5 sheets or 10 pages. Yeah.
It's August 9.
Yeah, so just what I was taking the witness to on the first page of the 2002 permit was the list of structures. And we agreed that there's 8 structures on the list. And the mining wastewater treatment plant is just one of them, the last one. And therefore, this was in response to the witness question that in the document that we were discussing right before, he did not understand or did not remember what the first 3 paragraphs refer to. Or the first, actually, all the document except the last paragraph, which deals specifically with the mine waters treatment plant. Have I refreshed your memory, sir?
Isté, že
Certainly. I do remember what is this CS024. It's been the most important mining wastewater treatment plant that was completely completed, which was not completed by Rimamura, was completed by Siderit. And it was approved by appropriate authority. What needs to be said as well, at that time we were not yet conducting any drilling, any mining works. That was still at original state.
Skip something. When you added that you were not drilling and any mining works, you said that because the temporary use of this mine waters treatment plant was limited to treatment of the water which was already in the winds, but it was not approved for use in connection with further drilling, is that correct, of the winds?
o tom sa vôbec nehovorilo.
It was not discussed at all how the water is going to be used. This was never discussed or negotiated about with anyone. This is something maybe I told you about. You take this. I was only describing the ideas how mining waters may be used. It was only a comment of mine and not some kind of use and arranging for permits for such use.
Not sure that you answered my question, sir, but there may have been a translation issue, so I will repeat my question. Am I right to say that the permit to the permanent temporary use of this one structure, mine waters treatment plant,
Áno.
was limited to its use for treatment of water which was already in the flooded decline? Correct?
Áno, na
Yes, for cleaning, not for treating, processing of the mining waste water. You're right when you said it. This was the only condition back then for this particular structure.
Only for the temporary use of this object, this was the
Áno.
only use which was approved for this object was to treat this water which was already in.
Áno. Áno.
Yes.
There was a common understanding at the time that when you resume mining works and you start drilling the winds, so first you have to take out the water which was in the winds, that has to go through this plant. And then when you continue drilling, you will also have to pump water out of the winds under construction, so to say. Is that correct?
Look, you have to realize that the throughput of the water was very small. So it was not a problem later to build a little pool and then connect that water into the water treatment plant.
Pretože v úpadnici
Because in the winds there was not yet any mining water. The winds had not yet struck mining water. The water was coming from the explosives storage.
Was it your understanding that when you start drilling the winds, you will have to pump water out of the winds under construction? Yes or no?
Yes, certainly you're going to have to. You can't leave it there just to be obstructing the drilling work.
You needed to have first a permanent approval for this mine waters treatment plant, and second, you needed also a final approval decision with respect to the 7 other water treatment construction objects that we saw in the decision 2002. Is that correct?
Look, I'm kind of confused by now what are we talking about? I can't really get my things straight. These individual structures, which are listed here, the 8 structures, including the water treatment plant, was done again by Rimamuran. Rimamuran back then had a valid permit from Rudný projekt Košice, according to which design they were supposed to build this. Now, they were starting to make amendments to that design, and they have requested this Rudné Bane Design Bureau to make those amendments for them to their design. And basically, perhaps you are hinting at whether we have then forwarded these designs to the building permit authority. I guess we did, because there were no protests coming from them during that period.
I'm afraid that you haven't answered my question. I will repeat my question exactly as I asked it.
Please do, because frankly, I do not understand the interactions you're suggesting. And the witness said he's confused. So if he's going to repeat it the same way, there's no use. He's confused.
Yes, I will try to address the confusion. If we look at the decision of August 9, 2002, it lists 8 construction objects. Do you follow me?
No.
Yes.
Yes. The last one is the mining wastewater treatment plant.
No.
Yes.
I believe that we have established that this last object had been approved for temporary use in 2004. Yes. The
Yes.
was limited to the treatment of the water which had flooded the winds. Correct.
Yes.
We also established that if you were to drill the winds further, you first needed to pump out the water which was already there. Correct?
Yes.
That water would be treated in the mining wastewater treatment plant in accordance with the temporary use. Correct?
No.
Yes.
And now, if you were to start drilling further, once the winds is empty, you would also need to pump water out as a sort of continual process.
I think this is a yes or no question.
Isté, že tam
Certainly, the water has to be addressed. The minimum of the water there.
Use of the mining wastewater treatment plant did not include the treatment of this new water, so to say.
Well, it did include it, because the water during the entire flooding was seeping out of the mine, going through the water treatment plant. So the water too was part of the temporary solution, the mining water. It was part of the mining water. There was no other water in the winds.
Just to make absolutely certain we speak of the same thing. I mean the water which would go or continue going into the winds once you start drilling the winds. Did the temporary use of mining wastewater treatment plant include, authorize treatment of this water?
umožňoval.
Yes, it did allow.
Refresh your memory on that point. I believe it's tab 36. It is page, this is the decision which authorized the temporary use of this plant, correct? Please go in English translation, it is page 4. There is 9, 10, then Roman 2, A. It authorizes the temporary use of this one CS 024 mining wastewater treatment plant. And then in the following paragraph it states in English, the mining wastewater treatment plant will be used to purify mine waters drained from the areas of the winds tunneled so far. And I put emphasis on tunneled so far. Does it refresh your memory, Mr. Rozložník?
Tak to mi
It's a completely clear, already drilled area. That's the 90 meters, 43 meters of it.
And when you start drilling, you go beyond what has been tunneled so far. Can you
ale
still use...
množstvo vody sa nezmení.
But the amount of water will remain unchanged.
Množstvo vody sa nezmení.
The amount of water will stay the same as it is here.
Response, Mr. Rozložník. This provision says tunneled so far. I understand this means, as you just said, what had been tunneled prior to July 2004. If you start tunneling more, you will be outside the scope of this provision, wouldn't you?
To je to.
This is a wording of the Water Administration Authority, tunneled so far. I'm again quite confused, not sure where you're aiming with your questions. I cannot understand it, because these are very technical and very easily resolved things.
The first 7 documents from the list we have on page 1 in the 2002 decision. It's called, in English, SUMP, settling tank and surface water drainage from the tailings pile, drainage of forest road over the tailings dump, stream adjustment, water tower, water distribution, and sewer. Do you agree with me, sir, that the decision we have seen on the temporary use of water structures explicitly referred only to the last item, mining wastewater treatment plant, correct?
Ei se on len.
I believe that your answer was not translated. Sorry, could you please repeat it?
Now, which one? The one I said before. What we are discussing here now, as it relates to the water, I'm a little confused about that, because I cannot understand where your questions are aiming in this regard, to which issues, because all the data or information about the water conditions are easily resolved technically, and they could have been easily resolved.
The decision in 2002, it lists 8 structures.
Áno.
One of them, the last one, was authorized for temporary use. The other 7 ones were not. Do you agree with that?
Ako to myslíte?
What do you mean that the previous ones were not permitted for temporary use?
Ale mali povolenie toto.
But they did. This only pertains to the submitted design. But this gentleman who approved it was all addressed beforehand.
I regret I have to do that again, but please go to tab 36, first page. This is the decision on temporary use that you refer to, is it?
Isteže.
Yes.
Certainly I have.
If you go to page 4, under Roman 2, it grants
No tu.
the permit to temporary utilization, which specifically refers only to the mining wastewater treatment plant, correct?
Ale tu predsa predošlo.
But the previous paragraph, it talks about the entire structure. It could be construed as the separate structure, but the way I understood it was the entire structure, so it means all the structures listed.
Not what this decision says expressly.
No je tu termín do toho, tak
There is a deadline there. I say again,
Back, and this is the last time we go there, to the decision from October 2004. This is the one which was at the very end of document tab 37. Yeah, and here, as we have gone through it, in the biggest paragraph, you are being given deadline to finish. No, I'm sorry, I need to get to the English version. You are being given a deadline to finish surface structures waterworks implemented as part of the work drifting of the winds talc deposit of the Gemerská Poloma to May 30, 2005, correct?
áno.
yes, certainly.
Means that those structures were not finished yet when this decision was issued. Is that correct?
Ale
But we have already begun completing them, but later the mining area was withdrawn from us. How could we have then continued when they have taken away from us the mining area in the first months of 2005?
Thank you. And now I omitted one thing with respect to the 2002 decision to explain why it was so important. And this is really the last time we go there. So, the second last. If you go to page 3 of this document, not sure if it is also in Slovak page 3, because in the translation it's the very end.
prvé slova povedzte.
You have Roman 4 obligations of the work investor. This is Rosmin, right? Are you with me, sir? And then, if you go to condition 5, please. I will read it to you. The investor may relaunch the mining operations, yet after having the surface structures commissioned, when the conditions for operating of the work will be set out.
Však my sme na tom pracovali.
But we have been working on that. We began by the end of 2004. We had completed a new water treatment plant that was completed. It never went into operation because the excavation area was taken away from us. We have completed the works SO04 and other structures as well. So we have been working on it. We would have completed it all.
Do you agree with me that this condition 5 means that you cannot start mining works at the deposit until the 8 structures mentioned on the first page of this permit are put into operation?
Nesúhlasím, pretože som
I disagree because I explained it to you.
veci, ktoré sú povrchové, neuznáva ako banskú činnosť. Čiže my sme banskú činnosť mohli reálne robiť aj bez toho, že by sme toto uviedli. Tak to je.
They were disconnected. Sorry.
Should we repeat the answer, or please repeat your answer?
Apologies, we had lost the power for a minute here. So equipment is back online. We lost the equipment for a minute.
Áno, zopakujte, prosím, odpoveď.
We basically had been working very hard on that by the end of 2004, having built a new water treatment plant, which was completed. We've also completed the other treatment plant, SO024, we were discussing so much, and we would have had completed all other additional structures as required by the water treatment authorities, water administration authorities. And I have hinted what you should discuss with experts from mining office, that they did not consider and do not consider surface structures as mining activity. So we could have continued drilling the winds without putting these structures into use. So I disagree with that, but that is how it is construed.
Je to legislatívny.
It's a legislative, some kind of...
You are telling us that the drilling of the winds is not mining activity?
Ako to som nikdy ne...
I never said that. Mining activity is not surface structures.
Okay, maybe have a little short break now. I will try to reorganize my questions.
15 minutes.
Thank you, Mr. Chairman.
The Pekash?
Thank you, Mr. Chairman. Mr. Loznik, we will continue. Please go again to document tab 37, exhibit C 259, but this time we will speak about the agreement itself and not the decisions of state authorities which were attached to it. First, I would like to correct one issue which is a pure translation issue. At page 9 of it, the date in the English version is incorrect. It states May 11, 2004, but I believe that it's uncontroversial that, in fact, it's 5 November 2004. Do you agree with that, sir?
Áno.
Thank you.
Yes, I do.
Then, please go to Article 4, which is on page 2.
Nemáme tu slovenský preklad.
Oh, you don't have the Slovak version? I apologize. Okay, I will then ask the question easily. Is it your recollection, sir, that the contractual price for Siderit's work was agreed to be 76 or almost 77 million Slovak crowns?
Áno.
Yes.
Yes.
Áno, presne.
Yes, exactly.
Have that money on your account, sir? On Rosmin's account, I mean.
Nauč
On the account, this amount of money was not in its full on our account, but within the agreement we've provided immediately 4 million of crowns to Siderit to begin preparatory work. And gradually, as the work would progress, the owners would transfer necessary funding to pay for the invoices.
Remember, sir, how much money you had on Rosmin's account after paying those 4 millions? If I have my math right, 77 minus 4 is 73 million Slovak crowns that you still needed to pay. So, how much money did you have on your account after paying the 4 million?
to si
I don't remember. But I do know that besides the 4 million we gave Rima Muraň 1 additional million for the high power electrical line. But how much we had in our accounts, I don't remember. It was not a large amount.
I told you that according to the financial statements that you signed, Rosmin had cash of 294,000 Slovak crowns, which is less than 10,000 euros.
no prečo
Why would it surprise me?
It's within the range that you would expect.
I'm unable to respond to that, but I'm convinced that consequently, if any payments were necessary to be made, the owners would transfer the necessary money for those payments.
Now please let's go to Article 7.1 of the agreement. It's on page 6. And here I will read it out loud for the translators to translate it for you because you do not have the Slovak version. It states, the contractor shall keep a site diary for the purposes of construction documentation, which will include all activities on site with the date, time, and description. The work shift manager is required to keep the site diary in the prescribed site record book, and this will always be available for examination at the site. The response and signature of the person specified by the customer is required for recording fundamental changes in the technical execution of the works, and other fundamental facts.
áno, je mi to jasné.
Yes, it is clear to me. We have kept such diary. Was kept by Mr. Mihok from Siderit.
Let's now look at that document, tab 43, R141. So, on the first page, we have our English translation says construction diary, not site diary, but this is just a translation issue, of the structure opening of the Gemerská Poloma talc deposit in the excavation area of file number 74E. Are you with me?
To, ktorá strana to je? No tu, hej. Aha.
Yeah. And then there's some technical information we can skip. And there is one part, unfortunately the pages are not numbered very well. Towards the end of the document, actually, there is daily records from the structure, it's called. I will count it for the tribunal. It's like 4 sheets down the first page. Mr. Rozložník, do you have the Slovak version of it?
Áno.
Yes.
Áno, mám pred sebou.
Yes, I have it in front of me.
And again, I think I will read that to you because the Slovak version is handwritten. So if you have any difficulty understanding the handwriting, just let me know. And
Nie, je to pekne písané.
It's well written.
so the diary starts on September 29, right?
Druhého, hej.
On the 2nd, on 29, yes.
And if we look at the description of the work which was done that day, we see that those were, in the English version, digging works on the object SO024. Can you see that?
Áno.
And this is the water treatment plant that we were discussing, which had been approved for temporary use. Correct?
Správne.
Correct.
And then we have entries for October and November. So if you turn, it's like, what is it, like third page from the one that we were at. We see the works performed on 25 November 2004 and 30 November 2004.
Áno.
And we,
Yes.
at that date, they finished object 018.2, and this was handed over to Rosmi. Correct?
Áno.
Yes.
If we turn the page again, there is no activity on the site until 8 December 2004. And the only entry there is the inspection of above ground objects with the attendance of DMO, Rosmin, and the production director of Siderit. Can you see that?
Áno.
Yes.
The site inspection that Mr. Buffy from the DMO
To ten.
performed on that day, yes. And then again, we have nothing for a week until December 14, 16, where we have alteration of the portal of the winds by covering with soil and alteration of the surroundings in front of the winds. Then nothing for a month. The next entry is 17 January 2005. And the task performed on that date is pumping of mining water from the winds through power generator. And this type of entries then continue until the very end, which is like 5 there is the instruction, or maybe on the 14th of February, there is the instruction of Rosmin to stop activities on the site. So, sir, would you agree with me now that, so generally, does it correspond to your recollection of the works which were done at the site?
No,
Now, when I'm looking over it, yes.
That the water was being pumped only in January 2005 until, let's say, the beginning of February of that year. Is that correct?
When it's written so in the diary, and it is so.
No, there's, so it was after the inspection of Mr. Buffy, correct?
Correct.
There are several things which I find somewhat odd, sir. The first one relates to the 8th December 2004. Do you agree with me that the entry does not mention any work being actually performed? It only mentions the inspection?
no však
Well, it is clearly written down in the protocol with participation of Mr. Buffy and the time and date when it occurred, just like it is in the record.
I agree with you that we will come to the protocol in a moment, but isn't it odd that the side diary would not record any activities?
I'm unable to explain why it's not written down here that the work is actually performed some work there.
Go one page back. No work had been performed for 1 week before the inspection, correct?
akože sa
What do you mean no work was performed? In a diary it's not written there, but do realize please that it was winter. There was a meter of snow below 20 degrees centigrade below freezing point, so it was not easy to work under those conditions.
And then there is 3 days of activity in December, 14 to 16, and nothing until the second half of January. Would you agree with me, sir, that this does not look like a very intense work?
pozrite,
Look here. During this period, it was known that in the commercial journal was published that we shall be taken away from us the excavation area. So you can realize under what psychological stress we would be under such circumstances, including the investor and the contractor.
The announcement was published on December 30. Would you agree with me that it cannot explain lack of activity in December?
30. decembra.
30 December.
Sorry, there's it's not the annulment. I will correct it for the transcript, which is not correct. The announcement of the tender was published on December 30, 30. Would you agree with me, sir, that it cannot explain lack of activity in December?
It was on the journal on the 30th. However, when was it sent to be published?
Sir, are you suggesting that the public or you were informed of the dispatch of the announcement to the how do we translate it?
O zaslaní toho som informovaný nebol.
I was not informed of the dispatch of such an announcement, but there were some hints already available. I could feel them.
We go to the second half of January. See there, it started pumping the water out of the winds.
Áno.
How is it consistent with what you have just said, that because of the publication of the tender you were holding back?
No, pretože
Well, because we still believed that the removal is not final yet. We still were convinced that there will be another solution presented.
Okay, sir, now let's go to paragraph 63 of your witness statement. And it would also be useful to have bundle 1, the one that we were working with yesterday during the cross-examination of Mr. Raubal and Agyagos, and document 12, which is the minutes from the inspection of December 8th. And the number of the minutes is R57.
tomu. Áno, máme to.
Yes, we have it.
You state in paragraph 63 that Director Mafi conducted an inspection of the deposit which lasted over 2 hours and led him to conclude that everything was in good standing and to confirm that Rosmin was authorized to continue mining activities until November 2006.
Áno.
Yes.
Point me to the confirmation in the document tab 12.
No, tuto není to napísané.
It is not written here, but by Mr. Buffy saying that everything is legally in order, I took it that the legal document is also a permit for mining activity.
Okay, now you refer, I assume, to the last sentence of this document, which says, during today's inspection, no facts were discovered indicating breach of legal regulations in force, correct?
Správne.
Correct.
What legal regulations was Rosmin breaching as of December 8, 2004, with respect to the assignment of the excavation area?
Neporušoval žiadne.
They did not violate any regulations.
Then in the let's go to paragraph 67 of your witness statement. We are done with this document, tab 12. Do you have the Slovak version of it?
Áno.
Yes.
When I read the Slovak version of it, I must say that I'm completely confused, sir. Because, could you please read out loud the first sentence?
Banskú
Mining Act of 2002 enabled the removal of rights for mining activity in case that in breach of the activity would exceed the period of 3 years. To me, this should be excavation area instead.
Accurate in Slovak?
Banský
Mining Act of 2002 in accordance with the act enabled the revocation of mining rights in the event of interruption of mining activities of a period exceeding 3 years, which is not fully correct either, because it should be written that in case, according to law, the excavation shall not commence. The word excavation is key.
Yeah.
je to z mojej
Yeah.
strany nesprávne.
From my side, it's an incorrect wording.
Add an incorrect translation into English. And this time this is not the issue that we were discussing.
Správne tak, jak
Let me correct it again. Mining Act of 2002 established that organization which does not excavate within a 3-year period shall be removed or revoked its mining rights in the excavation area. However, here, in this case, because that is what we are discussing about, here I'd like to express my unequivocal and definitive opinion. As I understood this Act of 2002, let me try and formulate definitely with a final, from my side, the way I understood it, as follows. Excavation in the Mining Act is opening of deposit by mining activity, but without, emphasizing, without excavating of the exclusive mineral. That is how I understood this act.
Read out loud the second sentence of this paragraph for the same purpose.
v tomto smysle nasledovne
In this regard, the consequent Mining Act of 2007 with force of 1st June 2007 clarified that the mining activities under 2002 Mining Act did not mean excavating. It's a controversy there to what I've said before. But the statement I've written down here, please do not take that into consideration. But take into consideration what I said just before. This is my opinion about this act.
And then in the following two sentences, you discuss the decision of the Supreme Court
áno,
in fairness to all the comments I got from my learned friend, I will ask you a fair question. Do you feel competent to comment on the decision of the Supreme Court?
ja myslím, že najvyšší súd
I think the Supreme Court had only confirmed what I just said. This is the way I understand this, because the term excavation was not put correctly in the Mining Act and it was not explained sufficiently legally in the Act.
You were victim to incorrect translation. My question was whether you feel competent to comment on the decision of the Supreme Court.
nie, najvyššie
No, definitely not to the Supreme Court. That's the supreme body in the Slovak Republic, so I can only accept it somehow.
What I meant is whether you feel competent to answer my questions regarding the wording of the decision of the Supreme Court.
You should not be asking me this question.
I respect that, sir, and that closes my cross-examination.
Thank you very much. So, redirect.
Sir, I understand that by Dobin Valle, you, in answer to Respondents' Council's questions, you mentioned that you understood this at the time of the amendment of 2002 until the revocation in 2005 to mean starting Dobin Valle to mean starting works in view of digging and not extracting. Is that a fair summary of how you understood it?
Áno, tak
Yes, this is how I understood it, that the opening of the deposit by mining activities without extraction of the mineral.
Then in paragraph 59, I believe, of your witness testimony, you mentioned that you and Mr. Agagos met Mr. Baffy at his office in October 2004. The question is, did he indicate to you that he understood that term Dobin Valle to mean something else, or did he ask you or expect you to have started or to start extraction?
That we begin with extraction, it is written exactly in the protocol, the way it was. I did participate there in person, and it was discussed in the protocol, but whether we should begin extraction, he never said that.
Okay, then let's go to the inspection. C28 tab 31 of the opening bundle. You must have the Slovak version. If you go to the second page, in between I should add your October and
No.
this expansion, this inspection, there was a notice to commence work. Then there is this inspection. In the second, in the first page, there is reference to the May 31st, 2004 permit that was valid until November 13th, 2006. It lists you, Mr. Baffy, as a participant. And in the second page, it says, it was found on site that since November 18, 2004, Siderit performed and completed construction work, and it goes on, mining water treatment plant. Then it goes on to say, furthermore, it was discovered that Siderit had performed other works. Then at the end, during today's inspection, no facts were discovered indicating breach of legal regulations in force. And the question to you, sir, is that did Mr. Baffy, are you listening?
Áno, počúvam.
Yes, I'm listening.
Did Mr. Baffy, during that site inspection, tell you, oh my God, you're only performing this type of work? It should be extraction by now.
Mr. Chairman, I object to this. This is a completely leading question.
Takéto niečo som nepočul od neho.
I never heard him say anything like that.
Mr. Garafi, please avoid leading questions.
Did Mr. Baffy express to you or not that you were imminently or not breaching any regulation?
V
Sir, this
žiadnom
is
prípade
still
také som
leading.
I have not heard anything like that, and he definitely never said anything like that.
I'll move on now to ask you, who is Mr. Baffy? Is he the T-boy at the mining office? Who is he? What's his function? Do you know?
Pán Buffy
Mr. Buffy is the chairman of the district mining office in the city of Spišská Nová Ves. Chairman.
Do you know whether he's retired now? Or still
ja
in
myslím, že
function?
nie, že
I think not. I think he's still working at this position.
Then if you go to tab 39, should be C36. In response to Counsel for Respondent's question regarding this decision, you responded that the Supreme Court only confirmed my understanding. And I want to point to you to paragraph 25, page 25, if you look at the Slovak version.
Mr. Garavi, the
Yes.
witness expressly refused to answer my questions with respect to this document, and
No,
I
He
respected
answered your
it.
first question. He answered your question. He said the Supreme Court only confirmed that there was no explanation of the definition.
Mr. Garavi, I was not asking any question. I was just reading to him the content of his witness statement.
He answered
And
your
then-
question. Anyways, can
and
I ask
then
you a
I
question on
was-
the Supreme Court? It's
If-
related to...
If he refused to answers question to me, then he should not be answering questions to you.
Don't take him to any part of this decision of the Supreme Court. If you want to, I mean, I think you will do it in your closing arguments. Use that decision, of course, that's your job. But he says he's not able to answer any questions, and that goes for your questions as well as for your opponents.
Professor Meyer, I think there's a misunderstanding. And
Maybe.
the first question that my learned colleague asked was answered. And then another question was asked on the ground that there must have been a misinterpretation. And in any event, the answer to the second question was that I'm not qualified to comment on a decision of a Supreme Court. So it's quite different than, in any event, sir, have you, are you aware of a act of 2007 that became effective on June 27 only, that set out what it understood or not in relation to the term dobinvanie used in the 2002 amendment?
I cannot tell you the exact wording, but it is perhaps as follows. Dobivanie, excavation of specific mineral in accordance with approved excavation method. It says dobivanie, excavation of the specific mineral. So it explains afterwards what the word means.
Afterwards, meaning what year, 2007? Is that, I was talking about the 2007.
2007.
2007.
Are there explanations of law or any official documents explaining before that?
Officially, if it was worded like that, I'm not aware of anything.
Nie sú mi známe.
It is not known to me at all.
I will, Mr. President, reserve for closing to walk again through the chronology of 2002, 2004. For the sake of time, I will just ask you a question in relation to whether or not you're aware of a decision rendered in 2003 by the main mining office that said that how do I say it? That expressed an opinion on the lack of information about the mining district court's request for documentation to Rosman before approval of authorizations. Maybe I could ask you to look at the document. It's easier. Do you know? should be tab 25. No. Yes. It's a decision dated May 5th. It's C226, Professor, and it's tab 25 of our first bundle. It's a decision dated May 15, 2003 that revokes the January 16, 2003 decision. And if you look at the fourth page, said that the mining office did not even clarify the documents that it requested for. Did you take part in that decision, in the litigation? Were you following these decisions?
I have to say that I would prefer not to respond to that. I don't feel as competent to be able to respond to that. I would have to get back to it. Please do take into consideration my ability of having to go back so many years in my mind.
Or redirect question. You're inviting me to.
No. Okay. Any question? No question.
Members of the tribunal, EuroGas has no redirect.
Thank you very much. So the tribunal doesn't have any question. So this is the end of your examination, Mr. Roslovnik, sorry. Difficulties with your name, sorry.
Mr. Very.
So we thank you.
It's quite all right.
Answers and the long time you've stayed with us. By the way, you may stay if you want. You'll see that with counsel on. So, what's next? Or who's next? Mr. Kukelchik.
This is correct, Mr. President.
Do you want to have a break? No, we just had a break, so I think we can. No? 5 minutes, okay. Well, just before that, I'd like to say something on behalf of the tribunal concerning the future closing arguments. Because we have the feeling that after we've heard your opening statements, there are many important points which have not been addressed either by one or by the other party or even by both. And we think that the most important part of your closing arguments should be, in fact, a kind of reply and rebuttal vis-à-vis the opening statements. And of course, your time is limited, 1 hour and a half. Maybe it could be extended if you agreed, for instance, to, if we have time, and maybe 2 hours. That could be a possibility. Sorry, I had not discussed that with my co-arbitrators, who may be furious against me, but it's so important. And if you have to sacrifice something, we'd better have you sacrifice your comments on what was said in the hearing under cross-examination than this reply rebuttal aspect. Okay.
Thank you, Mr. President. On behalf of Belmont, we would like to encourage the tribunal to put any questions they may have. As far as we're concerned, we will not be offended if certain questions may suggest a preliminary indication or something. We really welcome that and feel that it will be very useful.
It's possible that we indicate at some further points on which questions particularly would like to hear you, but do not count on it, and because it's a possibility, but it's not certain. So you are able to know where it hurts. in your respective cases, and where we'd like to hear you. Okay, so 5 minutes break. You wanted to add something? Good afternoon, Mr. Kukelchik. So you appear as a witness in this case called by respondent. You have a declaration in front of you. Can you please read it aloud? Is also
Áno, počujem.
Yes, gentlemen.
Myslíte vy?
Vyhlásenie svedka, áno.
Yes, of course. I shall read it. Good morning. God bless. Witness statement. I hereby solemnly declare on my honor and conscience that I shall say the truth, nothing but the truth and the whole truth.
Thank you. So direct examination.
If you'll just indulge me for a moment, members of the tribunal, Mr. Kukelchik, I note that you're wearing the official miner's uniform.
Áno, ja.
That is correct. It is a officially approved mining uniform of the Slovak Republic, which, according to protocol, may be used only for prescribed events and significant events. And I consider this one today a significant event. I'm wearing the uniform with respect to this tribunal. It dates back to 13th, 12th to a later period of 14th century.
A mohli by ste nám aspoň veľmi stručne povedať, predstaviť jednotlivé prvky uniformy, aspoň stručne.
They are also prescribed. It does not include any voluntary or any other statutory signs. It's a state employee uniform. On my left hand, it's state decorations. On the right hand, decorations of my status. State decorations are that of both Slovak and Czech republics. Also, equally the ones on the right-hand side.
We have nothing further. Thank you. I just thought that was some interesting history that the tribunal might enjoy.
Thank you very much. Now, cross-examination.
Thank you.
Mr. Garvey.
Still the morning, so good morning, sir. I'm counsel for Belmont Resources, and I will be asking you questions this morning. I would start with your first witness statement, paragraph 3. You mentioned that on June 1st, 2000, until December 2005, you were deputy head of the MMO before becoming the head of the MMO in 2005, correct? December 2005.
Odseku 3.
In paragraph 3, when I begin working as the district mining inspector, and then it follows with my further professional growth.
I understand. You know, the mining authorization of Rosman was revoked on December 2004, January 2005, correct? And I understand that at the time of revocation, that is in January 2005, you were the deputy head of MMO, correct?
Bol som zástupca.
I was a deputy chairman of the MMO.
And then, as the head of the MMO, you followed the process, meaning the challenges, the decisions, and some of the decisions in relation to the revocation, you rendered yourself, correct?
Since December 1st, I was the head of the district mining office, and I was supervising decisions. I was supervised by decisions made of the first instance body. The second instance body may not intervene with the first instance body.
My question was more general, sir. When you became head of the MMO in December 2005, I understand that you have been very closely following the subsequent challenges to the revocation that followed, and you even issued certain decisions yourself. I just wanted the confirmation of that.
I was supervising it just like any other case and any other proper remedy.
That was not your full-time job. If you move forward to paragraph 9, you explained that the government had concern about some dormant excavations. In paragraph 8, you mentioned that the goal of the Republic of Slovakia was development of the mining industry and contribution benefits to the economy. And explaining the history behind the 2002 amendment, you say that the situation, if you look at paragraph 9, according to its provisions, the previous law, in order to preserve rights to an excavation area, it was sufficient for an entity to apply for the authorization for mining activities within 3 years from the assignment of an excavation area. No actual activity was required. And then you go on and say, even if an entity did not take this simple step of applying, the DMO was not obliged but only authorized to withdraw the excavation area. The question I have for you is that, wasn't there a progress made if mining companies were simply required to undertake any work, any activity? Because before the 2002 amendment, according to you, one could just merely apply and have no actual activity. The question is, if you want me to emphasize, is that, would you agree with me that starting activity, if the mining companies were required to start activity, it was already a progress compared to what was going on before?
Chairman, I'm not sure I even understand the question. I just asked it to be...
Whether the witness understands. And if he doesn't, he will say so.
The question is very broad indeed, and it as though there are two things happening at the same time. First of all, I do not understand what Mr. Counsel is asking me. I also see a problem in translation, and when translation is correct, then the wording is incorrect, but because there is no district mining office in existence, and there is neither in existence a body issuing permit. It's always organization which authorizes permit for the excavation area.
Well, sir, maybe I could put it in a more simpler way. It's your statement at paragraph 9. You say it was sufficient for an entity to apply for the authorization for mining activities within 3 years from the assignment of an excavation area. Then you say no actual activity was required. So I'm using the same term as you're using and asking you to agree with me that if the government requires contractors, mining companies to start some activity it would have already been better than the situation as you describe it in paragraph 9, using your own words.
V odseku
Paragraph 9, I am describing a legal situation prior to the amendment in force in 2002, which was approved by the Parliament under the number 558. And the government may not otherwise describe other than through laws activities of mining office. The legal situation prior to this amendment did enable organizations such behavior that basically keeping the right of mining at the deposit was able to not. I apologize as an interpreter. May we ask the witness to repeat the answer? Interpreter has lost the witness. May we stop, please? It's way too fast. I apologize. We'll try slowly. The legal situation prior to the Amendment 558 of the Mining Act, enabling the amendment only could be done by the Slovak Parliament, enabled the organizations to behave in such manner that it was sufficient to request for permit for mining activity, and they had a holding right for 3 years of holding excavation area. May I continue?
Is some activity, is it better than no activity? And I think the common sense requires a straightforward answer is yes. Paragraph 9, to be blunt with you, to avoid time, you say the situation before the 2002 amendment was that no actual activity was required. And it's common sense, my question, and it deserves, I think, a yes or no answer, which is some activity better than no activity? You understand that question, right?
I hold that we discuss not an activity but mining activity. Mining activity may only be performed based on a permit. Based on that, which when organization had requested for such permit to be issued, and only professionally apt organization may request such permit which holds excavation area. And the request for mining activity is not a activity.
Sir, I will move on to the 2002 amendment that you described in the subsequent paragraph. And you say that the 2002 amendment required excavation. That's the word in the English translation to your testimony. And by excavation, I understand you mean dobivanie in the Slovak language. I apologize for the pronunciation.
Keď som pochopil,
If I understood the question correctly, if you're asking what is dobivanie, I understood the question.
Yes, so you're using the term dobivanie, correct? In the 2002 amendment, it uses this term, correct?
áno,
Okay.
Yes.
Would you agree with me that there is no legislator, no court that defined precisely what that term meant until 2007?
nie, nesúhlasím.
I disagree.
Are you aware of a law or a court decision that defined what was exactly expected, intended by that term?
Áno,